Now, a major blow for the Justice Department and its investigation into former President Trump's handling of official government documents. A federal judge sided with the former president in his request for a special master to review documents the FBI seized from his Mar-a-Lago estate. The order permits a neutral third-party attorney to comb through all the materials from the search. That person set to look for anything containing potential attorney-client privilege or executive privilege information. The move also forces the government to halt its own review of the documents collected during that August search at Mar-a-Lago. Justice Department lawyers argued the appointment was just unnecessary. They said the FBI's filter team, whose job it is to do exactly that, had already finished its own review for potential attorney-client privilege documents. The judge, appointed by former President Trump, cited potential media leaks in her reasoning. She wrote in the ruling, "In addition to being deprived of potentially significant personal documents, which alone creates a real harm, plaintiff, that is Trump, faces an unquantifiable potential harm by way of improper disclosure of sensitive information to the public." The judge said attorneys for both sides must jointly file a list of proposed special master candidates by this Friday. It's unclear if the Justice Department plans to appeal that decision. So let's bring in Ian Bassin. He's the co-founder and executive director of HTE Group, of the group Protect Democracy. He previously served as associate White House counsel under former President Obama. In that position, he helped officials make sure they complied with all the laws, the rules, the norms. So, Ian, can you talk us through this process of deciding what a president or any White House official can and can't take when they're leaving the Oval Office? There are a lot of rules around this, right?
Sure, and there weren't always. Prior to Watergate, there really wasn't any law on what records belonged to a president or to the people, or what a president could take or not take. And so President Nixon tried to take a lot of records with him when he resigned to California, including, of course, the famous secret Oval Office tapes. And so Congress responded to that by passing something called the Presidential Records Act, which makes it the law that any material that a president creates or receives in doing their job is the property of the American people and is retained by the government. There's a narrow exception for things like personal records. So say if a president writes home, "I'm going to be late to dinner tonight, I'll pick up milk on the way home." That's not a presidential record. But anything involving official business, that gets boxed up at the end of an administration and sent to the National Archives, and it belongs to the American people, and presidents can't take any of it.
And that's the exact question here, right? Because the special master is going to be allowed to view documents that are covered by, quote unquote, executive privilege, which is sort of a loose term that's evolved over the years. But we only have one president at a time, and President Biden is not asserting executive privilege over these documents. So how's that going to work?
Well, that's right. I mean, it's a real question because the Supreme Court has twice declined to grant executive privilege claims by former presidents. So once President Nixon tried to do it, and famously the court said no there. And earlier this year, the Supreme Court declined to intervene in a case where President Trump was trying to get the Supreme Court to block the disclosure of records that he claimed he had some executive privilege over before they went to the January 6th committee. So it seems clear that in the long run, this is not going to result in records being deemed privileged by the former president. Instead, what is likely going on here is former President Trump has been known to play a game of sort of legal rope-a-dope, where he uses the fairness of our justice system to delay an eventual reckoning or decision. And that's part of what's going on here. And the other thing maybe, as you noted, President Biden has strenuously tried to, I think, correctly stay out of this matter. But if this forces him to waive executive privilege here, it may be a way for the former president to try to draw President Biden in order to claim that this is partisan when it really is not.
And so that puts the pressure on the DOJ, right? Because they're faced with a decision now. They have not appealed this decision yet. So do you expect that they'll do that, or are they going to just try to work around it?
Well, I'm sure there's a very heated debate going on within the Justice Department right now. On the one hand, they don't want to play into this game of delay, and they know that an appeal might further delay things. So there are probably some inside the Justice Department arguing not to appeal it. On the other hand, the decision issued by Judge Cannon in this case is quite unprecedented and quite broad in making, I think, a pretty clearly, and the experts have all weighed in on this, legally unjustified injunction to block the Justice Department from even reviewing legally seized materials. And DOJ may decide that either they need those materials now to proceed, or they can't let that precedent sit on the books, and they feel the need to appeal even if they proceed with other parts of the order while that appeal is pending.
So a process win now for the former president. We'll see if he can continue that streak here. Ian, thanks so much for being here. Really appreciate your insights.
Shepard Smith here. Thanks for watching CNBC on YouTube.